Hey, folks, my name is Tom Olsen. The name of the show is Olsen on Law right here on News Talk WDBO. My guest today is attorney Travis Hollifield. He's an attorney right in Winter Park and handling employment law. And we have Bob from Orlando with an workplace question. Bob, you're on News Talk WDBO. Go ahead.
Hello. I had a question pertaining to lunch periods. My understanding is that if a person is paid wages and they work more than 6 hours per day, that the employer must allow a minimum of 30 minutes for lunch. Am I correct, or is that left to the discretion of the employer?
Typically, it's at the discretion of the employer as to when and how long to provide breaks. Now, obviously, an employer, typically for good employee relations, will permit its employees to have sufficient breaks throughout the day, and certainly if there's a multi-hour shift, to allow some sort of a lunch period. But there's no legal mandated requirement that an employer provide a set amount of time at a set time during the day for those breaks.
In an 8-hour day, then, if an employer, say, provides two 15-minute breaks in an 8-hour period and no lunch period, is that okay, in accordance with labor law?
Well, again, there is no set legal requirement that there be a specific amount of breaks given throughout the day or a length of time for those breaks, unless, of course, there's a collective bargaining agreement. Typically, that's going to be either public employers or private employers where there is a union-based contract that would set forth the amount of breaks that are there. But in the private sector, there is no such requirement.
Very good. Hey, folks, my name is Tom Olsen. The name of the show is Olsen on Law. You're listening to News Talk WDBO. We'll be back in just a few minutes.
The only station